Justices of the Appeals Court, now sitting in Boston, will attend before the Commonwealth. Draw near, give your attendance, and you shall be heard. Now, see the Commonwealth of Massachusetts. Court is open. Please be seated.
All right, before we start, I'm just going to say good morning to everybody, and I hope everybody had a happy and healthy Thanksgiving holiday. The panel hearing your case today consists of the three of us. To my right is Justice Shin, to my left is Justice Paul Smyth, and my name is Ariane Vuono. Don't think I need to remind any of you that you have 15 minutes to present your argument and that there is no rebuttal in the appeals court, but I will remind all of you that we've read everything that you have submitted to us. We know your case well, so you can get right to your most salient points as soon as you can. Right, with that said, I'll start with the first case, which is partially impounded. Antonio MEDEROS versus Commonwealth of Massachusetts, 2024-0947. Counselor, good morning.
Good morning, Your Honors. Fred Burkholder on behalf of Mr. MEDEROS. May it please the Court. My brief is thorough as I think it can be with regard to the issue that's presented. In essence, my argument is the following. Commonwealth failed to present sufficient evidence for a reasonable jury to conclude beyond a reasonable doubt that MEDEROS continues to suffer from a mental illness or abnormality or disorder that causes him to have a serious difficulty in controlling his behavior. Difficult case from my perspective in that due to the lack of directed verdict motions in the waiver, I'm stuck with a substantial risk of miscarriage of justice standard, which we all know is such a heightened standard that it's an uphill battle at best. However, under the last decision that was issued in MEDEROS, there was a determination or a repeat that a conviction premised on legally insufficient evidence creates a substantial miscarriage of justice. So, in essence, my argument is as follows. These cases are so similar to me in that they always look at several issues. They look at how their adjustment has been in the institution since the last time it was reviewed, and they look at their progression and treatment. The rest of it is basically static issues. This individual has a static 99 score of 5. That's never going to change. The percentages for that are well known. It's not the greatest percentage. To me, number one, that's not even a standard that's individually based. And secondly, I don't think it can be indicative of where he is presently, just simply because of the dynamic factors. So I don't want to talk any more about that other than answer any questions you may have.
Well, no, I just wanted to point out that, so as you indicated, the question here is whether the evidence was sufficient to determine whether or not your client is no longer a sexually dangerous person, right? And you would agree that there was testimony by 2 qualified examiners and by a 3rd qualified examiner who was also a member of the CAB who indicated that there was sufficient evidence that your client does continue to need treatment. So why isn't that dispositive?
It's a very good question. I know it's raised by my sister in her brief.
It was pretty much the same question that was in the last case.
Exactly. Yeah. And in essence, I was rereading the decision this morning with regards to the last case, and despite the argument of waiver, an analysis was still done by the court. And that's what I'm asking for this court to do.
Okay.
Now, to be brief, Your Honor, my arguments with regards to his progress are as follows. I think that the cross-examination details that are set forth in pages 33, 34, and 35 of my brief sufficiently set forth what I believe is an indication that he has improved in treatment. Just highlighting, Dr. Peretti indicated that he's learned to let out his emotions, respect boundaries, use support, walk away from potential problems.
I'm going to interrupt you. That may be, but would you agree that that was a question for the jury to resolve?
I think that there still has to be a basis in which for the opinion to be premised, and that's the argument that I'm trying to make. I understand where the court's trying to go with that inquiry, and that's basically why am I standing here, in essence. And my argument, again, is that if, in fact, the legal basis that has been established is not sufficient, that amounts to substantial risk of a miscarriage of justice. That standard has been in place. It remains in place unless it's been changed to my knowledge, and I think that at least gives me the right to stand here.
Well, you certainly have the right to be here, and the standard hasn't changed as far as I know either.
And that's what I'm arguing. And again, I understand and respect the fact that it's a heightened standard. I frankly, you toy with the idea of whether or not it's ineffective assistance of counsel. You come back to the same standard anyways. Why there was a no directed verdict motion that was filed in the initial first case or the last case, and this one, it's beyond me. But that said, we're back to the same place. So if I may continue.
Of course.
All right. And just to add what Dr. Peretti said, basically, he's identified his drug use, stress, being alone, feeling that no one cares for him, and were factors contributing to his sexual offending. Most importantly, she indicates that there's been no antisocial personality traits that were noted in 2021 or 22, and that she could not identify any specific instances of behavior demonstrating antisocial tendencies since 2020. Basically, what I'm saying is this. If you review his past decision, which I know is not in evidence, but in essence, it was highly dependent upon his OBRs. His OBRs have decreased since then. He's only had 5. Certainly one is of as egregious as possibly could be. As my sister referenced this morning, he made him knife and the like. And nobody can condone that. That said, that was 5 years ago. There's been nothing since. Also, there's not been anything.
In between that time, the time of trial, however?
Trial was in 23.
23, okay.
I'm sorry, trial was in 22. He filed his petition on 12/5/18, and that last meaningful OBR that I'm referring to occurred on, let's see, that one was admitted manufacturing a weapon for another resident and reportedly had knowledge of a plot to commit murder and subsequent escape on 11/6/2018.
Okay.
So past that, another one in 2018, possession of broken razor blades, verbal altercation in 2019, failure to firm serve of dietary needs, 2021, several contraband items removed.
So just under 5 years, okay.
Most importantly also, nothing of a sexual component, which did exist previously. 2013, obviously, discovery of some pictures. 2015, that occurs again to some degree. My argument is, in essence, that he's getting older. Antisocial personality disorder is known to diminish over time. The test, as I understand it to be how his behaviors manifest that and presented that, my contention is that with the modicum of treatment that he's had, which I admit is only stage 2.2, and he still has work to be done, he has made improvement. And as such, I don't think on a diagnosis of antisocial personality disorder alone that there should be sufficient evidence to convict him or continue to commit him. I think that the interesting quote with regards to that happens to be Dr. Colestra's, and I'll finish with this, Dr. Colestra's acknowledgement that antisocial personality disorder does not in and of itself predispose someone to sexually reoffend. I have nothing further unless there's any questions.
One moment, I'll check with the panel. I see no further questions. Thank you for your argument.
Thank you, Your Honor.
Good morning. Jean Holmes for the Commonwealth, and may it please the Court. There is no cause to disturb the jury's verdict that Antonio Medeiros remains a sexually dangerous person. Counsel's appeal here is simply targeted towards the weight of the evidence, as the Court has already talked about. In this case, the standard is the substantial risk of miscarriage of justice, and the jury considered this entire case, both the cross as well as the direct examination of the retained experts. Quite frankly, the retained experts actually bolstered in many instances, and their opinions were somewhat discredited by way of cross-examination. One of the experts was not even aware that Mr. Medeiros had created that knife, manufactured it for purposes of a murder and escape plot. In fact, he first testified that Mr. Medeiros had done nothing wrong or any incident since 2018, which was incorrect. Dr. Bard himself also seemed to believe that Mr. Medeiros was using a walker, and there was no evidence that he was using a walker. So I suggest the retained experts on cross-examination suffered from quite a bit of deterioration in any opinion that they had. But most importantly, both retained experts bolstered the Commonwealth's case. Dr. Bard admitted in testimony that the antisocial personality disorder, albeit he didn't diagnose it, but he said that Mr. Medeiros' sex offending was related to an antisocial personality disorder, was consistent and contributed to his sexual offending. Dr. Brown rather, specifically did say that that Mr. Medeiros had an antisocial personality disorder. Respectfully, given that the standard in this case is in the light most favorable to the Commonwealth, suggests that the jury verdict was supported by ample evidence of both mental condition as well as likely to reoffend sexually, and thus would ask that the appeal be denied. If there's no further questions.
All right, I'll just check with the panel. Questions here? No, no further questions. Thank you both very much. We'll take the case under advisement.
Thank you.
All right, our next case is Commonwealth versus Robert Bulgar, 2025-0151.
May it please the Court. My name is Daniel Ciccarello, and I represent the appellant defendant, and I appreciate the opportunity to argue in front of this panel regarding his conviction for indecent assault and battery on a child under 14. The basis of my appeal is that the judge should have allowed the motion for required findings because there was more evidence to show that it was accidental touching than intentional. And I think that there's two parts that I talk about in my brief. The first is the credibility of the alleged victim as opposed to what the defendant was saying or his credibility, and then whether or not it was accidental or intentional.
Let me ask you a question.
Yes, ma'am.
The jury could have and was entitled to reject your client's testimony in full, correct?
Well, they could have, Your Honor, but I think that the gatekeeper, the judge being the gatekeeper, should have ruled that there was more evidence to show that it was accidental. What the reason why I'm saying the issue, he should have looked at all the evidence, including the credibility of the two parties who were testifying, particularly the credibility of the alleged victim. Primarily because of the date that she said that it occurred, or the lack of the date that she had said that it occurred. She had said that it occurred during the weekday, it was in the fall, that it was after school, when there was more evidence to show that it occurred on the weekend, on a Saturday morning, and particularly in April 25th, because there
that
was...
sort of harkens back to my original question in just a little bit slightly different way, which is it was for the jury to decide whether or not the victim, alleged victim, was credible or not credible, correct?
Well, it is to the job of the jury to determine that, but it's also the job of the judge when ruling on a motion for required findings to take into account all the evidence that is presented at the Commonwealth's case and also at the defendant's case, at the end of the defendant's case. And I would suggest to you that there was more evidence, even in the Latimer standard, to show that it was accidental rather than intentional. And the issue has to be, so we look at, I would suggest that you look at the evidence of the defendant, that he, the issue about the credibility of the date, the credibility of the victim has to do with everything that she's testifying to, or a lot of what she testifies to, that it was after school, that she was wearing her uniform, that there were people involved, there were people outside at the fire pit. All of this has to do with whether or not her testimony about him intentionally touching her, I think is paramount to the judge's decision about whether or not to allow the motion for required findings. It was adequate testimony from the defendant that he just barely touched the breast.
Grazed is the term I think he used.
That's the term. Sorry. I just couldn't get that sound out. And that, while she testifies that he was holding, that he put his hand underneath her sports bra. I would suggest that because of the conflicting testimony there, that the judge should have looked at the credibility of the two witnesses. For example, looking at the defendant's credibility, you look at the fact that he went to the police, voluntarily went to the police to talk without an attorney. He had always told the same story to the family, that it was an accidental touching. Also, there was no testimony that he ever told the alleged victim to lie about this circumstances. There's no testimony that he had done this before. He had testified that he'd gone in there because she was in a bad mood, or she was depressed because of school, and so on and so forth. You know, the evidence. And he was doing it, he wanted to cheer her up by doing the same activity that was appropriate, or that was allowed, or that she did not find oppressive, the tickling. And that, so it was clear, he says that he was touching her rib cage and then went up and just barely touched the breast. She herself testified that it was only for 2 seconds and that she didn't really know how long it occurred. I would also suggest to you that, well, all that evidence that I just told you about going to the police, not hiding, not telling her to lie, never having engaged in this type of activity before, I would suggest to you that shows that there was sufficient evidence to demonstrate that it was an accidental touching.
I just want to make sure I understand your argument. You're not contesting that if the jury believed the victim, that her testimony alone would be sufficient to show it was not accidental. You are arguing that the jury should have found that the victim was not credible. Is that your argument?
I'm suggesting that the judge should have found that there was sufficient evidence to show that it was accidental rather than intentional, so therefore the element was not proven.
But if the jury credited the victim's testimony, do you agree that her testimony alone would be sufficient to show intentional touching?
If they believed it, yes. But again, I would say to you that it shouldn't have gotten to that point. It shouldn't have. And I would also want to make some statements regarding the cases that the Commonwealth had provided in their brief. I think I had said that in my reply brief, but I think that goes to show that this was that there was less evidence here showing that it was intentional than in the cases that the Commonwealth had provided. Barato, Bonanno, and Cormier. All of those showed that there was continuous escalating contact for an extended period of time, that it was not the first time that the person had done this, and all of that activity, all of those cases show or give a better, a finer point to the argument that this was accidental rather than intentional. If there's no further questions, I'll rest on my brief.
I'll check with the panel. One moment. No further questions. Thank you for your argument.
Good morning, ladies and gentlemen of the panel. May it please the court, Jennifer Thompson for the Commonwealth, Bristol County. Just to address the 2 points brought about in the appellant's brief, as the court noted, the testimony of the victim alone is sufficient to survive a motion for required finding, as well as to satisfy the elements of the indecent assault and battery of an individual under 14. The victim testified she was 12 years old at the time of the incident. The defendant was involved with her mother for a period of time in a relationship, essentially in the stepfather role, on the date of the incident that she recalled. She was in her bed. He came in, asked her if she wanted a hug because she was upset. She declined the hug. He still proceeded to attempt to hug her or grab her leg in a wrestling move. She tried to kick him away, and then he gets behind her, lies behind her, puts his hand in her shirt, touches her breast over her bra, and then moves his hand underneath her bra. Those are enough, that is enough testimony to satisfy the elements of the crime. So I'd suggest that Judge Lamar was correct in denying the motion and sending the matter to the jury to determine the credibility of the witnesses, because, again, as Your Honor said, indicated that the assessment of credibility is properly for the jury, not for the determination of a motion for required finding. Even, as I said, even if it was just the victim's testimony without the defendant's corroborating statements, there was enough to satisfy the elements of the crime. But here we had the defendant also acknowledging that he actually did touch her but claimed it was an accident. And I think what the defendant is suggesting here is that his claim of accident somehow deteriorated the Commonwealth's case. And I'd suggest that his claim of accident certainly did not deteriorate the Commonwealth's case. That, again, was for the jury to decide who to believe in that circumstance. As far as there being more evidence that the touching was accidental, again, there was testimony of the victim indicating that it was intentional based on the facts and circumstances surrounding the incident. She described, again, he put his hand under her shirt, had his hand on her breast for a couple seconds, and put it underneath her sports bra and left his hand there until she left the room. So I'd suggest, again, that's enough to establish intent of the defendant to touch the child's breast. And even if there wasn't, there's facts and circumstances that support the inference of intent here. And the cases cited by the Commonwealth in my brief support that inference. And we have certain elements that support the inference, such as the defendant was in a family relationship with the victim. He was in a role of essentially a stepfather. He was substantially older than the victim. He acted surreptitiously by waiting until other people were outside of the home. He was alone with the victim, and he touched her indecently. Although his 18-month son was in the home, the other adults were outside of the home. And there's an element of force in a sense in which she declined a hug and attempted to kick him away when he tried to wrestle with her. So I'd suggest that the facts surrounding the indecent act itself, the act itself that otherwise can be explained as innocuous or ambiguous, the facts support the fact that he intended to touch the child's breast. So those are essentially my arguments as set out in my brief. If there are any questions?
I'll check with the panel. None here, and none here. No, thank you both very much for your arguments. We'll take the case under advisement.
Thank you.
Okay, the third case on our list today is Commonwealth versus Francis PENA, 2024-0970. And before we begin, Counselor, I understand you had a question as to how you would refer to the not guilty verdicts in the case. And you may go ahead and refer to them.
Thank you, Your Honor. Good morning. May it please the Court, Elizabeth Lazar on behalf of Mr. Pena. The main issue in this case is whether the prosecutor's closing argument contained improprieties that resulted in a substantial risk of a miscarriage of justice. Following that is, if the Court does find that, the question is whether the case should be remanded, given concerns that double jeopardy is implicated. And a secondary substantive argument concerns the failure to provide a specific unanimity instruction. But if I may, I would like to address some of the points in the closing argument. There were a multitude of both types and repeated impermissible statements in the closing argument. I counted probably close to 20 individual statements that fall under 6 different categories. The Commonwealth does acknowledge that the prosecutor overstepped at times, but characterizes some of these as ill-advised, and don't think that the Commonwealth gives enough credence to the depth and breadth of these errors. For instance, the first, right off the bat, The defense was that the victim had brought these charges out of revenge or anger, and both the defendant and the victim testified. The prosecutor started off the closing by saying the defense wants you to believe this was brought out of revenge, certainly permissible way to start the argument, but he followed that up by saying that doesn't happen.
What do we do about the indiscernible portion of that statement?
Let me just look at the transcript.
So that doesn't happen. If the earlier sentence is indiscernible, how do we know what that was referring to?
Well, I think even in, I don't think that the content there would change the "that doesn't happen" statement,
How
because
do we know that for sure?
well, how would it affect that clause? I don't, because
Indiscernible
he's,
could be anything. We have no idea how many words were indiscernible. It could be one word. Man, we just don't know.
right. I think because it's a standalone sentence and saying that doesn't happen on its own is enough to vouch for the witness and also suggest that the prosecutor may have some special knowledge about how charges are brought and why she's here, which is inappropriate. But there's more than that, as set forth in the brief, and I won't go over every error, but I would like to just address one error that became kind of a theme in the argument, that Mr. PENA was somehow drunk, and describing this in kind of very inappropriate, not forceful language, excuse me, fueled by alcohol. He said everything was happening, he was drunk, he was on an alcohol jealousy-driven nature getting revenge. That's how it appears in the transcript. And then he also said after spending the night drinking, he gets behind the wheel. The only testimony that Mr. PENA had a drink or drank at the party was one sentence, was one question by the prosecutor. Were you drinking at the party? He answered yes. No other evidence came in. How much he drank, when he drank. There was no evidence that he was inebriated at all. But that type of argument, the fact, urging improper inferences and arguing facts that weren't there was completely inappropriate, and especially when combined with the type of language that conjures up an image of somebody out of control and driving drunk, which is, a serious accusation and certainly inappropriate.
Counsel, what do you say to the Commonwealth's position that the judge instructed the jury multiple times the closing arguments aren't evidence?
Yes, and that is a consideration that's important in assessing whether this was a substantial risk of a miscarriage of justice. These errors were so pervasive and pointed that a specific instruction was warranted. I would point the court to Beaudry, 445 Mass. 577, where the court examined two claimed errors. One was that the prosecutor intimated that the victim should be believed because she took the time to show up in court. After that, the judge gave a specific instruction saying, you are not to believe somebody merely because they came to testify. And the court found that specific instruction cured that. But the court did not give a specific instruction where, in response to the prosecutor where the prosecutor invited the jury to make an unsupported inference. The court found that was not cured by a general instruction, that it required more specific instructions.
And is there a burden on the court? The Commonwealth isn't arguing that these lack of objections from counsel were strategic. I'm not sure you could make that argument. But is there a burden on the court to intervene when there are so many mistakes in closing arguments, similar to perhaps in Dwyer, for instance, the prior bad acts, the court found the Dwyer court found the trial judge should have intervened at some point, sua sponte. Is there any case law to support that a judge should do the same on a closing argument in the absence of an objection?
I'm not aware of any, in interrupting the argument, kind of stopping it as it's going, when there's no objection. I'm not aware of one, right? I didn't look at that for this particular issue, but there certainly is an expectation for specific instructions if the judge does see these types of errors arising. because the general instructions oftentimes, even though they do touch upon important issues of impartiality, can be inadequate, where the improprieties are, this is from Nemec, the same situation, hard driving and sustained. And that's what happened here. And just to move on to the substantial risk, that is why general instructions were insufficient here. And there are 4 other considerations. The defendant did not object, so that is not in favor of finding a substantial risk of a miscarriage of justice. But all the other factors are. These errors were not collateral. They went to the heart of the case. This case involved 2 people. There were no eyewitnesses. And these errors touched directly on the character and credibility of the defendant and the witness, and the victim.
How do you propose to evaluate the fact that there was the photographs of the injuries suffered
Photographs,
by?
yes. Certainly there were photographs of the injuries. The defendant argues that those are not enough to make this case overwhelming. The photographs were taken hours after this happened, when the victim had left. She had gone somewhere else for many hours. These photographs were taken later, and they are merely probative to whether the defendant engaged in these acts. For instance, it might be a different case if she had called, if the photographs had been taken minutes later when the police came. We have this intervening time, which I think makes them a little bit less probative. Even with those photos, however, this case was not overwhelming, and the Commonwealth acknowledges that. And in such cases, even if it could be considered strong, for argument's sake, the prejudice cannot be overcome by the evidence here. And I would point the court to Durgo, which is cited in the reply, 474 Mass 1012. And in that case, a similar situation where there's no eyewitnesses, no physical evidence, and the prosecutor's inappropriate comments were not single-handed remarks. They were pervasive, and it was, not offset by an overwhelming case.
What about the 2 not guilty verdicts? How do we assess those in evaluating substantial risk?
Yep. I think the court must consider it to some degree, but in looking at the issue that's presented, what did the jury find him guilty based on the correct reasons when they did find him guilty of something? Or was it a fair verdict? Was that guilty verdict fair? And so the court should engage in the same analysis, looking at the errors and looking at the other aspects of the case, and ask whether that was based on the correct permissible evidence, and that they weren't swayed by thinking, oh, he must be a bad guy, we've got to do something. Maybe we'll find him guilty of 1. We can't obviously go in the juror's mind, but
right.
the same...
it's a difficult question, right? So there are errors in the closing, as the Commonwealth concedes, many in the nature of misstatements of the evidence. This was a short trial, right? It was 3 witnesses. One was just the detective who was authenticating the photos, right? Yes. So the jury had just heard these witnesses, 2 witnesses. They didn't forget the evidence that they just heard, right? They're instructed that it's their memory that controls. They convict him on the 1 charge that's supported by photographs and acquit him of the other 2. So how do we determine that there was a substantial risk on the 1 conviction?
I think the court needs to look at the factors as a whole. I think we don't know, again, the basis for that 1 verdict. I don't think that because there was a not guilty, it doesn't mean that there wasn't a substantial risk here, that the guilty verdict that did arise wasn't infected by these errors. I think it's important to look at, but I think that the factors point to a substantial risk here in light of all the improprieties. And relatedly, the question, could the jury sort out these excessive claims is another, the last factor that the court should consider. cumulative effect of repeated errors make it hard for the jury to sort out these claims, even where the court does credit the jury for following instructions and being able to discern some excessive claims. Santiago 425 Mass 491 talks about this. Again, repeated references. The court did acknowledge that jurors, as I mentioned, are given that credit to follow instructions, but at times when the errors are so pervasive and numerous, that becomes difficult or impossible. So for those reasons, there was a substantial risk of a miscarriage of justice based on these improprieties. The court, for that reason, should set this verdict aside. And the question, defendant has argued that double jeopardy principles prevent a retrial, where the Commonwealth has claimed that is premature, that this court should remand for further proceedings. The Commonwealth cites Hirasenko for that proposition, where the defendant on the first appeal was successful and went back on remand for a retrial. He moved to dismiss those charges based on double jeopardy. The judge denied the motion. Eventually, he came back to appeal that decision, and the court agreed that double jeopardy principles applied. The Commonwealth argues that that's what should happen here, but it shouldn't. If the court looks at Ribeiro, which is cited in the brief, the question was whether a judge erroneously dismissed 2 charges. There were 3 charges of rape. The judge dismissed 2. Only 1 went to the jury. The Commonwealth appealed, and the court found, yes, the judge should not have dismissed these charges, but retrial was inappropriate for double jeopardy reasons, and that same principle applies here. The jurors were given evidence of acts that occurred that could be considered assault and battery. They found him guilty of one, not guilty of another. We don't know the basis for that guilty verdict or the basis for their acquittal. If the case should be retried and the same evidence presented, the defendant could be convicted based on the same facts, or he could be acquitted, or he could be found guilty of actions for which he was acquitted. The court has no way to discern the basis for the verdicts, and therefore he would be exposed to double jeopardy on remand.
Why isn't the first set of acts, the pushing and the punching, one course of conduct?
Well, the Commonwealth proceeded on 2 separate counts. They did not argue that this was one course of conduct. It might be a different case if there was 1 count of assault and battery.
It's an all or nothing, right? It's not like the jury could believe the first punch occurred, but the second punch didn't occur.
Well, their verdict suggests that because they did find him guilty of 1 count of assault and battery on a family member and not guilty of another count.
Which when I read this is kind of confusing because it seems like from the initial discussions between the judge and counsel that the second assault and battery was supposed to be an act of strangulation, right? And then that never came out in the evidence. And then when you read the closings, it seemed like both attorneys differentiated between the first, I'll call it the course of conduct, the first altercation involving the pushing and the punching, and then the incident with the knife. So there's a separate charge with the dangerous weapon, which involved the knife. So why isn't it reasonable to assume, not to assume, why wouldn't it be reasonable to conclude that the assault and battery was for the first course of conduct?
I would argue because it's not entirely clear from the evidence, and the jury expressed confusion about what's the difference between these 2 counts. It's not clear, and there's no way to tell for certain. And when double jeopardy is implicated, any doubts are resolved in the favor of the defendant. And I don't think that
So are
that
you
type of
saying
inference.
that the jury could have convicted based on the assault with the knife? And that's the reason why double jeopardy would apply?
Well, that was an acquittal for a deadly weapon.
Right,
yeah.
but there was a deadly weapon charge, and there were 2 A and B charges. He's convicted of only 1.
Correct.
Okay. Are you saying that the jury could have convicted him on that charge based on the incident with the knife?
No, but there were multiple other actions by the defendant, and the fact that the Commonwealth brought 2 charges based on those other
And
four
I'm not
things that happened.
understanding what you're saying he could have been acquitted of, that he might then be retried in violation of double jeopardy on remand.
Yes, because some jurors may have believed he pushed her, he went on top of her. Oh, he didn't punch her 5 times. We don't know what the basis for that verdict is
Okay,
because
but there are cases that say pretty clearly that when it's, the acts are closely related in time and space, you don't need a specific unanimity instruction because it's essentially an all or nothing proposition. They're not going to believe one part of it occurred and not the other.
But the way that the indictments were presented, and they were presented with these 2 charges, it could, and it did lead to confusion. I think there is a basis to conclude that double jeopardy is implicated here. Are there any further questions?
Thank
Okay,
you.
Thank you very much.
May it please the court, my name is Ken Steinfeld, and I'm appearing today on behalf of the Commonwealth. I just want to begin with a broad overview of the standard here in broad brush why this conviction should be affirmed. The standard here as to all the claims is a substantial risk of a miscarriage of justice, which only occurs, obviously, when this court has a serious doubt that the result of the trial would have been different. The result here was 1 conviction and 2 acquittals. So for this court to credit the defendant's claim, it has to find a likelihood or a probability, or at least have a serious doubt that had these errors not been made in closing, and had there been a specific unanimity instruction, the jury would have acquitted altogether, which I think is highly unlikely. I don't think there's any substantial risk that that would have happened had these errors not occurred. And of course, the Commonwealth has acknowledged significant errors in the closing. I'm not going to stand up in front of you and obviously say that they were not. I've said that some were outright plain error and some were skirting and some were close, but I think I've gone pretty far in acknowledging those errors. But I think that the acquittals in this case cannot be overstated, as Justice Shin has alluded to already. They show a jury not overwhelmed, not believing basically some of the things that the prosecutor said. And also, as Justice Shin has pointed out, this was a very short trial. They just heard the evidence. They were told repeatedly how to treat closing argument. And I don't want to press this too far, but the arguments made by the prosecutor were so not supported by the record. The slamming.
In other words, they were so bad that they didn't create a substantial risk because they would have had to have been rejected?
Well, I'm saying that the jury would have said, what is he talking about? I didn't hear anything about slamming. I didn't hear anything about blood gushing as she was being slammed. So I think that if they had been a little closer, I'm not pressing this argument too much, but I think it might have worked in the defendant's favor that these statements were clearly not based on the record. And they had the photographs, they had the testimony from the victim, and all they needed to find was that he had assaulted and battered a family or household member. And
The acquittals are really critical to your argument, right?
Oh, absolutely,
Okay.
yes. Yes, I think it would be a much harder case if they had convicted on all counts that had been submitted to them. The threats, of course, were not. I do want to.
So how do we know exactly what happened in that jury room, that maybe they reached a compromise? I mean, how do we know exactly
Well,
when
we
the
know
errors
that-
essentially permeated the closing, as you say?
Well, but if it's, I don't know, of course, how we tell whether or not it's a compromise. There was certainly sufficient evidence to support the 1 conviction. And in his closing argument, the prosecutor pinpointed the knife as the ADW. The knife to the neck was the basis of the ADW. He said that explicitly in his closing. He did not say as to which acts went to each of the assault and battery on a family or household member. So I
What
think
was the basis of the second charge?
Well,
The second A and B charge?
it was not distinguished. There's no place
so-
in the record where the Commonwealth said the first count goes to this act and the second count goes to that act. The judge said before the jury started to deliberate, do you want me to give them a specific unanimity instruction to tell them which act goes to which judge? And defense counsel said no. And of course, they talked about it earlier, and they laid out which possible acts might be formed the basis. And the judge said, well, the knife is not a possible basis because that's the ABW. He also said the strangulation was not part of the police report and therefore was not part of it. So it can't be the strangulation. So basically the two had to be the getting on top of and the punching in the face at least 5 times. The Commonwealth should have been more
specific. It couldn't be the knife?
Pardon me?
Why couldn't it be the knife?
Well, the Commonwealth did say in closing that that was the basis for the ADW, not for the
A and B.
assault and battery on a family or a household member. So I think we know, or can reasonably assume, that the verdict was based on the 5 punches. And as this court has pointed out, we don't need to know whether it was the first, the third, or the fifth, or the second. It has to be one. It's a continuous course of conduct. And the evidence, the photographs, showed that there was an injury to her face, which was totally supportive of
So now I'm even more confused about what happened in the jury room. So
Oh, well,
you're saying the jury must have convicted based on the punches, but found that he did not get on top of her?
no,
Okay.
I'm saying that's a theoretical basis, but I think because of the nature of the injury sustained, the likelihood that they found that him getting on top of her, which is not sort of a classic assault and battery, when you have testimony of punches in the face, I think that's pretty clear. That's a punch in the face. People know that that's an assault and battery. And if there's testimony that that happened, plus photographs that show that it happened, I think, of course, we have no idea what happened inside that black box. But I think based on our experience and the evidence, it is more than likely, if not highly probable, that they found that for the sole count that they found not guilty on was based on her testimony that he punched her 5 times. And she got pain meds at the hospital later that shows there's a temporality in time. So I think the jury fairly could have found that those injuries that she were documented hours later happened that morning.
Also, the issue is it's very speculative. I mean, for all we know, they could have found she sustained that injury in the photograph because she was slammed on the ground, which wasn't in evidence, but was argued by the Commonwealth. I mean, isn't it concerning the Commonwealth didn't even have a theory for the assault and batteries?
Concerning, yes, but not a substantial risk of a miscarriage of justice. I agree this case could have been tried better and more specifically on that point. But as this court has held as to the specific unanimity part of it, if the evidence is sufficient to support one conviction and he's only convicted of one, then there's no substantial risk of a miscarriage of justice. So I agree with Your Honor, and I think
But your sisters argued, what if 3 of the jurors found that he pushed her and 3 of the jurors found that he punched her? We have a problem, don't we?
If we knew that that had happened, yes, then they would not.
Oh, we don't
have
know it
agreed
didn't
specifically.
happen.
Right, but he didn't ask for the specific unanimity instruction. He was asked if he wanted it, and he said no. So we're back to a substantial risk of a miscarriage of justice.
Well, we're back to not knowing what they convicted of. We have 1 not guilty and 1 guilty.
Yes, that's true.
Isn't it better practice for the Commonwealth? I mean, it's a very interesting place, District Court. I'm not sure this ADA was new or younger and experienced. You could look at the transcript and maybe infer that from some of the comments he made, including he would leave it up to the jury to charge the defendant. It's hard to interpret that comment, but they're charged with very important duties, such as a charge like this, a crime like this. And wouldn't it be a better practice for these attorneys to have like special verdict slips so
Yes,
that
and
have
also
a theory of the case to present to a jury so that we're not right here wondering what they did and what they didn't do?
Yes. Ideally, the complaints themselves would have set forth which acts. Ideally, the defendant might have moved, and I'm not saying he was obligated to, but he might have moved for a bill of particulars and saying, what are you talking about? Which of these goes to which? He did not. Ideally, or I'm sorry, not even ideally, but a better practice and a good practice and a standard practice should be to have the prosecutor in his opening or her opening and in closing to state this act goes to this chunk. And some prosecutors, of course, in a multi-count case will have like a sexual assault. They'll have, well, this act goes to this goes to this goes to this. It's always helpful. We didn't have that here, but that does not mean that this conviction should be reversed because there's no substantial risk of miscarriage of justice. But I have to agree, and I totally agree that, yes, it would have been far better if that had happened. And yes, this is from the BMC, and I'm not, I don't want to cast any aspersions, but, you know, you have some prosecutors who are not as experienced as others, and this happens as part of the, you know, I don't want to say the learning process, but it is, as you go on, you learn these things might be helpful, but that doesn't mean that this
No, my
conviction
comment's
is-
more to the office than to the specific prosecutor.
Yeah, no.
I think it's more of a training issue. Again, I can only infer that, because I can't infer that the office is okay with some of the comments that were made in closing, as you've conceded.
Right, and
appropriately so.
I beg to decline to answer any question about what our internal processes are as a result of this sort of thing, but I can assure the court we're doing our best to make sure that this does not occur in the future, that this is known, that this is, you know, the far better practice. I do want to go back to one thing. I don't want to argue against myself, but Justice Shin pointed out that the indiscernible at the start of the closing argument, that we don't know what he said, that didn't happen. That doesn't happen. The start of that sentence is, defense counsel wants you to believe that Ms. Martinez is indiscernible to get her revenge. So I think it's pretty clear that's a reference to what the defense lawyer said in closing, that she had fabricated her allegations to get her revenge. So I don't necessarily think that the fact that it's indiscernible makes that any better, that statement that doesn't happen. I think it's clear what he's referring to, that it does not happen, he said, that people come to court and tell lies about being beaten up in order to get their revenge. I don't know if that's helpful. I just wanted to add that. Unless the members of the court have any further questions, I'll be happy to rest on my brief.
One moment, and I'll inquire.
Pardon me? I didn't hear.
I said one moment, I'll inquire of the panel, which I've just done, and they have no further questions, and neither do I. So thank you both very much, and thank you for answering all of our questions, and we'll take the case under advisement. All right, we're going to move on now to the fourth case on our list before we take a brief morning recess. And that's case number 2024-1284, Kathleen Glasgow-Turow versus Daniel Turow. And if I have mispronounced your client's names, please let me know. And in your case, if I mispronounced your name, you'll let me know. One moment till we get everybody here. All right.
Thank you so much for allowing me to be here today. I chose to be here to represent myself just so you could hear from me directly. It's out of respect for this court that I do that, because I don't want anybody to come between me and you when it comes to expressing my thoughts on this case. I'm not here today to ask you to overturn anything. I'm not asking you here to create new law. I'm not asking you to interpret the judgment that you've already ruled on. The case that we're dealing with arises from findings of contempt against me that were entered in August 2024.
Why don't we start there for a moment? Can you tell me precisely what order and judgment you are appealing from and when you filed that notice of appeal?
The original appeal is based upon the judgment nisi that was entered in March of 2024. That judgment was appealed and heard by this court.
Right. And that case has been affirmed, and that was
Yes.
that decision was rendered at
Yep, and
around
I'm
the
not-
beginning
I'm
of
not here
August,
to-
right?
I'm not here to challenge that.
Of course not. Well,
Yeah.
but right now you're here appealing from what exactly? The judgment
I'm
of contempt
appealing-
that was entered on August 9th, or
I'm
thereabouts?
appealing from, they arise out of the same facts, Your Honor, and they've been
Well, no,
consolidated.
you filed a notice of appeal.
Right now I'm talking about 1224, the original appeal. But there has been that appeal of 1224, the judge issued subsequent findings. And I'm not appealing those findings. I'm here to talk, I'm here to request that the judge in May, she stated that additional facts were needed. So I'm not here to change.
I'm a little confused. Let's just back up for a moment, all right? We're not here to discuss the actual underlying judgment of divorce.
That's
that was
correct.
appealed and affirmed.
That's correct.
All right. We are here to discuss a judgment of contempt, correct?
That's correct.
All right. And when did you file a notice of appeal from that judgment? And is it correct that we're talking about a judgment that was entered in August of 2024?
That's correct. That's what we're talking about.
Okay. And you filed a notice of appeal with respect to that judgment, if I'm
Yes.
not mistaken, on October 3rd.
I don't know. I don't have that date in front of me.
Okay, well, I have it from your appendix here. It indicates that a notice of appeal filed on the ruling, which is contempt, dated 9/11/24.
Yeah, and that ruling, the reason why that date is there is because I had filed a motion to amend, and when that motion to amend was rejected, that's when it triggered the appeal.
Okay, so would you agree with me that a notice of appeal filed in October would not be sufficient to appeal the judgment that was entered on August 9th, 2024?
My understanding is that I had to file a motion to amend, and when that motion to amend was rejected, that's what triggered the timeline for the appeal.
Okay, so if we were to disagree, for example, then what we can say, I think what you're saying is that your notice of appeal at least directly relates to this motion to amend or motion to reconsider, correct?
Yes.
Okay. All right. And you think that it's sufficient also to bootstrap, I'll put it that way, to use a non-legal term, the judgment on August 9th. And of course, you know that your opposing counsel says that it is not sufficient and that the notice of appeal is not timely.
Yes, Your Honor. And one thing that is not mentioned, I actually gave notice of that second one on June 2nd, and that is supported by emails and documents from the court. The court was not allowing e-filing of the appeal, and so I had to go to the person that was handling appeals at the North Fork Court, and she just said she was too busy to get it done.
Okay.
But
These are facts that we can't really consider
Yeah,
because they're not in the record.
I'm actually not here to dispute. I'm actually here for, if I could be allowed to continue, I'm here for another reason. Meaning that the contempt finding in August 24 and November 24, a subsequent hearing was held, and in May 2025, an order was issued. I'm here to talk about that order. That order required me to put money into escrow because there were additional findings of fact that were required. So the sole issue today is not to dispute the finding of contempt. It's to talk about the scope of instructions needed on a remand that the court itself suggested was necessary.
When you say the court itself, are you talking about
The original contempt court.
I believe you used the date May. Did I hear you use the date?
Yes,
Okay.
May 2025, a ruling was issued, and I filed a notice with this court that the original contempt judge modified her findings and found me not guilty on several of the things that she had originally found me guilty on. And then she also ordered that an amount be placed into escrow pending further fact-finding. And so the only thing that I wanted to talk about today, and I'll talk about anything, that's why I'm here, is what is the scope of the additional facts that need to be entered into record that don't exist anywhere? And I can give you an example of that.
And where in your brief did you address this?
It's addressed throughout the brief. And one of the, if you look at paragraph 10 of the judgment Nisi, for example, it says in the judgment Nisi that education expenses not paid by the parties during the pendency, that requires a fact finding. There's no evidence anywhere that has concluded how much tuition was paid in the pendency. That's an outlying fact that needs to be resolved. The appellee is arguing that the judge meant to undo stipulations. Your Honor, for 200 years, no court has undone stipulations or contracts between parties that were not supported by a fact in law. There is no finding from any court finding that those stipulations should be undone. If those stipulations were to be undone, there needed to be a legal rationale for doing it, which includes fraud, misrepresentation, unconscionability, mistake of the parties. Those are legally established grounds for undoing a stipulation. So I'm not even debating the finding of contempt. What I'm debating is there's still facts that have not been entered into any record that need to be resolved.
And how is that before us in this appeal?
It's before you where I was not allowed to present any evidence.
Where?
It's in
At the hearing that was
court.
at the hearing that
In
was
the
held.
court.
Well, let me just interrupt you because I really need to be clear about the chronology of the case so that I can understand your point of view. Are you talking about the hearing that was held in July of 2024 prior to the judgment of contempt being issued?
Yes, ma'am. Yes,
And
Your
you're
Honor.
saying that's where you were not permitted to introduce certain evidence?
A hearing in July and then a hearing in November, and it's stated in the trial record. When I came to
Back up, hearing in November of which year?
2024,
Okay.
because the court held 2 hearings. And in July of the initial hearing, my attorney, I was represented, asked for a hearing, and he cited JDM versus JAM, which is a
You say you asked for an evidentiary hearing, because you had a hearing, but
Asked
you
for a
asked for an
hearing.
evidentiary hearing.
The
Yeah.
court declined that
Correct.
hearing and said that the issues were not sufficiently complex.
Correct.
Okay?
Yeah.
That's not a standard for an evidentiary hearing. An evidentiary hearing, according to JDM, is there a material fact in dispute? So when I went to court, I asked if I could present evidence, but my attorney left with the evidence. So I didn't have any evidence with me.
The documents.
The documents.
Right. And you explained
I
that to the judge.
explained it to the judge.
Yeah.
Yes, Your Honor.
Yeah, I know, I saw the transcript, you
Yep.
explained that to the judge, and the judge continued forward
She
anyway.
continued forward anyway.
Mm-hmm.
She continued with the hearing. So I was not in a position to actually present anything. I have less than what I have right now in front of me. So she found me in contempt, and then I appealed for the basis that are laid out in my original brief, but I filed a motion
Claiming that you
to
didn't have
amend.
a full and fair hearing.
Yes, Your Honor.
Okay.
And when I filed my motion to amend, I explained in detail why the findings of contempt, the original findings of contempt, were not appropriate. And I can go through each one of those reasons. They're explained in my brief in detail. Starting with impossibility. One of the findings of contempt was I didn't transfer money from my retirement account. The wife was required to sign the form to get that transfer to happen. She never signed the form.
But now that was fully before the judge during the contempt hearing in July. You explained that to the
I
judge.
explained it to the judge.
Right then, at that hearing.
I did explain it to her. And the judge did not allow me to question my wife. The judge didn't direct any questions to my wife. And when she asked the attorney sitting to my right, their response was, we sent him a form. They did not mention that the form wasn't signed. They didn't mention that it had the wrong account number. And so the judge took that as they must have signed the form. So I asked the court to reconsider some of the findings. The ambiguity and mistakes in the calculation of the...
I'm going to back you up again. You asked the judge in your motion to reconsider her findings. And that was filed, can you tell me exactly when you filed that and where it is in the appendix?
The operative document is page 124 of the addendum to the table, addendum to the original brief,
To your original brief?
to my original brief.
Okay.
So the judge found me in contempt. I asked her to reconsider. She declined that. Then I filed my notice of appeal, and she scheduled another hearing in November of 2024.
Okay.
At that hearing, I came prepared with evidence. As a matter of fact, the appellee herself admits that I had 500 pages of documents. And I was ready and prepared to present any evidence, not only to establish my innocence, but also to talk about things in the judgment that we need finding of facts on that don't exist. The judge, sua sponte, refused to allow me to present evidence. When a judge refused...
Is there a transcript of the hearing that you're alluding to in November 2024 been provided to us?
Yes, they have been.
Okay.
And they're quoted. In fact, the judge in that case says, I don't know why you continue to ask me to present evidence. Your testimony is your evidence. She would not allow me to present any evidence. And to the credit of the attorneys to my right, they didn't object to the presentation of the evidence. This exclusion of evidence was done sua sponte, which means that exclusion of my evidence put the judge in an advocacy position because that evidence benefited me, and she excluded it. And so when I filed the second appeal, it was the same essential reason that we're here today. I don't know how I'm going to fulfill the obligations of the divorce judgment if I'm not allowed to present evidence. I don't know how that's... If we just talk about the tuition, it says tuition paid during the pendency between the parties. So all the money that was paid in tuition has to be accounted for. Your Honor, I don't know how I can account for that tuition if I'm not allowed to present receipts. That's the fundamental fact that needs to be entered into the record. So when I approach this court today, what I'm asking for is the ability to just present evidence. And I'm not even asking you to undo anything. I'm not asking you to overturn anything.
What you're asking for is a second hearing, basically, is what I'm hearing you say.
What I would like, and I know I'm running out of time, and I appreciate your patience. I'm not an attorney, and I don't do this for a living, so I apologize, and I appreciate your patience with me. You can understand I'm nervous. There's $674,000 at stake here. That's how significant this issue is.
So, again, and I know that I don't want to belabor the point in terms of dates and notices of appeal, but you've just now been talking about what occurred at a hearing in November of 2024, and the only notice of appeal that I located in the records thus far is one that predates that in September of 2024. Am I missing something?
I don't understand, because June 2nd, I filed the notice of appeal with this court, and I filed it at the Norfolk court. And it was so important to me, I followed up almost
June 2nd,
daily.
2024?
2025.
Oh, 2025, okay.
Yep. The judgment came out in May of 2025, and I immediately, knowing how important this was, I immediately sent notice to the opposing counsel, and I immediately sent notice to this court and to the Norfolk court.
Right. Okay.
And I'm not asking for anything other than the opportunity to present evidence. That's really what I'm asking for today.
So just in a nutshell, your view is that the judge abused her discretion by not giving you that opportunity at the hearing?
Yes, Your Honor. I would just like the opportunity to, I don't know how the judgment can function if I'm not allowed to actually present evidence to support what's in the judgment.
All right. I understand your point of view. I'm going to just check and see if my panel members have any questions. No. All right.
Thank you.
Thank you.
Thank you. May it please the court, and good morning. My name is Nancy Freed, and I, along with my partner Anna Martinetti, have represented the wife in this matter since 2020, when the case was first initiated. I must admit that I'm a bit confused, having just heard the argument that was made. As I understand, we are here today because the husband challenges two judgments of contempt that were entered by the Norfolk Probate and Family Court. And those judgments were on August 9th, 2024 and May 14th, 2025. And as the court has already pointed out, this case was appealed once before. After a 3-day trial, husband appealed the judgment. There was an argument here before the court in May of 2025, and this court entered an order affirming in all respects the judgment of the Norfolk Probate and Family Court And that judgment, this court's order entered on August 1st of 2025.
All right.
When I hear the argument made by the husband, who just stated that he is not an attorney, he is in fact barred, I understand, in both Massachusetts and in Michigan. He has throughout these 5 years been represented on and off by counsel, but is not represented at this time.
I understand that. Could you shed some light on the issue that I raised earlier about the actual, the validity and the timeliness of the notice of appeal? And are there more than one?
I will try, and I do have a timeline. So there are 2 judgments from which he is appealing.
Right.
They arise
The initial
out
judgment on August 9th.
August 9th and May 2025. He appeals both of those judgments. The allegations for the underlying complaints for contempt arise out of the same judgment of divorce, which was affirmed by this court. And so there was a hearing in July of 2024. That was the August 9th judgment, and that was where he was first found in contempt for having failed. There were 6 separate provisions that he had failed to comply with. The second complaint for contempt, he was still not in compliance, so we...
That was when that was filed in September. Are you talking about the September of...
Correct.
Of 2024?
Correct.
Okay.
They are, and he's still not in compliance. Some of the judgment has been paid, some of it has not.
Let's focus for a moment on the judgment of contempt that was issued on August 9th, 2024, or maybe and docketed potentially on August 13th, but that particular judgment. Is it your view that there was a timely notice of appeal filed from that judgment?
There was not.
Is it, as far as you know, is it the notice of appeal that is apparently filed in connection with that judgment filed on September 11th, filed on October 3rd, 2024?
I'm sorry.
That's all right, okay. Are you aware of the fact that a notice of appeal was filed with respect to a judgment entered on September 11th, 2024?
My
Sure.
partner had more of the procedural background than I do,
Okay.
so I apologize. I am told the first notice of appeal was timely, the second was not.
Okay. Thanks.
Second, you're saying is not timely because it was premature, right?
The second was not timely because he didn't refile after
Right, because
the
it was premature.
motion to amend
Right,
was
so-
denied.
But that, he only needs to refile if your motion to amend was served within 10 days of the judgment, which I didn't see that it was. The judgment issued on May 14th of 2025. It's docketed on May 22nd, and I have the service date of your motion to amend as June 4th, 2025, which is not within 10 days. Do I have that wrong? In which case, the notice of appeal that he filed on June 20th would have been timely, unoperative from the judgment.
I have a motion to amend.
Served June 4th, 2025, right?
I have June 3rd.
Regardless, that's still not within 10 days. So I don't see what the problem is with the second appeal, to be honest.
I may not fully have the process clear. I am clear on whether or not we think that either judgment should be reversed or remanded.
Okay.
And may I
You may address that
proceed
issue.
on actually on the substance? So in going back, and beginning with the standard of review. A civil contempt requires a clear and unequivocal order and a clear and unequivocal disobedience of the order, and that the lower court's judgment should only be reviewed if there is an abuse of discretion or an error of law. Nearly all of the husband's arguments in both complaints for contempt and his argument here today seek to set aside the lower court's judgment of divorce, which has already been affirmed by this court. And the contempt proceedings from which he appeals did not permit him to relitigate the underlying judgment of divorce. The judgment at all times remained fully binding, even while the matter was under appeal, because the husband had filed multiple motions with both the lower court and this court asking that the judgment be stayed pending appeal.
I agree with that with respect to some of the grounds for the contempt judgment, but let's take, for instance, the ground, one of the grounds was that he failed to transfer the funds from his IRA, and he says, I couldn't do that because my wife wouldn't sign the necessary forms. Wife says, no, I guess she says she signed it. Why isn't that a factual dispute?
If we go back to the underlying pleadings, although the husband filed an answer to the first complaint for contempt, he did not assert any defenses in his answer. He denied the allegations, but there were no...
I'm not sure you have to raise that in your answer to preserve it. If you have a hearing on a contempt complaint and you're saying, and the respondent says, I am not in contempt because it was impossible for me to comply with this provision of the divorce judgment because my wife wouldn't give me the necessary forms, that seems to me to be a factual dispute independent of the divorce judgment, that there should have been an evidentiary hearing to decide whether it was in fact impossible to comply.
It is my understanding that it was not impossible. It was my understanding that it was an IRA.
Why isn't that a factual dispute? This is what I'm not understanding. Some of the grounds, so there are 6 grounds for the original contempt judgment, and I agree with you that some of the husband's arguments appear to be directed to the underlying divorce judgment, which is improper. But it seems to me that on some of the grounds, he's arguing he couldn't comply, and that is a defense to a contempt complaint. So why wasn't he entitled to present evidence as to whether he could comply with some of these provisions?
He admitted that he hadn't done it, and I understand what he said. Yeah. It is also my understanding that it was an IRA rollover. It should have been very simple. He was able to roll it directly into her Fidelity account. I understand
how do we know
that we provided with an account.
Finding?
How do we know that?
How do we know that without fact finding?
He had 90 days to do it, and it wasn't done, and he was provided with a transfer form from Fidelity to Fidelity with her account number on it. It's a rollover of the IRA that literally Fidelity could just transfer electronically from his account to her account.
Where is that fact found in the contempt judgment?
We sent the papers to him in July. What he was supposed to do...
Where can I find those facts in the contempt judgment?
I don't think you would find them. They weren't... I think that he said he didn't have the form.
Were those documents presented at that hearing?
They were not.
Excuse me, they were not.
They were not. It was actually made more complicated, as many things in this case, because he was ordered to transfer $237,000 from a Revity IRA by June 28th of 2024. And instead of transferring it to the wife, what he did and admitted is that he had rolled his Revity IRA into a Fidelity rollover IRA. So rather than complying with Revity IRA to the wife, he rolls it from his Revity into Fidelity which now had to go from Fidelity to the wife. It was ultimately transferred, but it wasn't done the way that the judgment required it to be done. When we were in court that day, the judge asked him, "Did you do it?" And he said no. He admitted that he didn't do it. He didn't raise.
This was at the hearing held in July
That
of
was the
2024.
hearing that was held in July. In the November transcript on page 46, it is my understanding that he had what he needed to make the transfer. That is my understanding. And that he admitted that he had not made the transfer. The transfer has nevertheless been made. Many of the transfers that are required have been made. There are still some that are outstanding. It isn't actually even clear what he's looking for today. As we prepared and as we filed multiple documents and spent hours and hours and considerable sums of money to prepare to defend 2 notice of appeal on 2 complaints for contempt, he came into court today and told you that he wasn't complaining about anything. He seemed to ask you to go back to temporary orders that would be pending between the time the case was filed and the time the case went to judgment. He files 2 notices of appeal asking you to find that he is not in contempt. I don't know if he's asking you to remand the case for findings behind the judgment of divorce, which you've already affirmed.
Well, let me ask you this. You've indicated that some of the issues on which, or some of the conduct on which contempt was found have now been satisfied, that those transfers have been made. So is some of this case moot as far as you're concerned?
It should be. There is a remaining payment that he hasn't made. There is a compliance hearing that is scheduled for February to determine whether he is in compliance. He has paid most of the judgment between the time of his last appeal, between the first appeal, then he paid it before the judgment entered on the second appeal, but it had already been heard. There was a delay in the judgment for the second hearing. The first judgment came very quickly. The second judgment did not. And before we received the second judgment, he had already made the payment. In fact, the second judgment had required that $174,000 be paid into escrow. He had already made that payment. We filed a motion to amend, informing the court that the payment had already been made, and that was allowed. So there's $127,000 that remains unpaid under the judgments out of the original amount, and there is approximately $66,000 of fees and penalties that have not been paid, arising out of both judgments, and that's set for a compliance hearing.
Okay. I see your time is up, so I'm going to check with the panel to see if any further questions. And I see none. So thank you both for answering our questions, and we'll take the case under advisement. We'll take a short recess.
This is session, please be seated.
So, thank you for your patience. The next case is the Department of Children and Families and Another versus Mother and Another, 2025-0590. One, of course, reminding you that the case is impounded. And second, we have some time splits. And I have it as 10 minutes and 5 minutes and 7.5 and 7.5. We all good about that? All right. Thank you very much. Please go ahead.
Good morning. Excuse me. May it please the court, I'm attorney Catherine Foster on behalf of the mother in this appeal. The single justice abused their discretion by denying parents' motion for reconsideration based on the rationale used to deny mother's petition for a late notice of appeal, namely good cause and meritorious issue. To show good cause, mother had to show that her misunderstanding or delay was not the result of her own carelessness. Mother's affidavit attached to the late notice of appeal petition makes that showing. In the first paragraph, mother knew she needed to file a notice of appeal or something within 30 days after trial. What she didn't understand was that father's filing would not cover her. If it stopped there, then it would have been a result of mother's carelessness. But that's only the beginning of her journey to appeal. The second paragraph shows that after 30 days, she spoke with trial counsel. Trial counsel told her that after 30 days, she lost her opportunity to appeal. Perhaps understandably, after hearing that news, mother succumbed to her disability for a few months and relapsed. But after the court issued the decision on September 30th, mother immediately reached out to her trial attorney to see if she could appeal. He consulted other counsel and returned to her and said, no, there's no option for you to appeal. Mother didn't let it go. She continued to pursue her opportunity, and it wasn't until mother spoke with father's appellate counsel that she learned about the narrow window of time that she had for her last opportunity to appeal. And as soon as she learned about it, mother contacted the CAFL appellate unit. Mother was assigned counsel. She spoke with counsel, provided direction. She signed and returned a notice of appeal that was filed in the trial court by trial counsel. She signed and returned affidavits of indigency and provided an affidavit along with the notice of appeal. This is the kind of extraordinary circumstance that the rule was designed to allow, where a parent mistakenly relies on poor advice from counsel despite asking multiple times about whether they can appeal. Mother should not lose her opportunity to appeal, and it was an abuse of the discretion.
Can I just ask you a preliminary question?
Yes.
Do you agree the only thing before us is the denial of the motion to reconsider?
Yes.
Okay. So on a motion to reconsider, the motion has to point out something, a reason to reconsider. So how did the single justice abuse his discretion by not reconsidering his original decision?
The single justice abused their discretion by not reconsidering when they did not, it seems that they did not consider mother's affidavit.
Well, he expressly did in the original decision and said that the reasons she gave were inconsistent. There's no excuse for a 1-year delay. I mean, I think it was literally like right under the deadline of a year.
Yeah.
I hear your arguments, but our review is for abuse of discretion on a denial of a motion to reconsider. So why was it an abuse of discretion to find that the affidavit gave inconsistent reasons for a 1-year delay?
Well, the court, the single justice merely denied with one word, so there actually is no rationale to challenge aside from the rationale given for the denial of the petition for late notice of appeal, which is why I addressed my arguments to that rationale. There were additional arguments in the motion to reconsider addressed specifically to the points of law that the court erred in deciding against the notice of appeal, specifically applying the general rule of common law rather than recognizing that ICWA allows a challenge at any time to judgment, even after adoption, even after everything's finished, based on violation of ICWA. The single justice abused their discretion by failing to distinguish the precedent, especially adoption of Leonard, where this court found that the word must meant that the part of ICWA that requires expert witnesses before termination was mandatory. And here, if the court does, in denying it, the court overlooked the must and made it permissive. And this is a case, in terms of ICWA, first impression in this court. This court has never considered a case where there was absolutely no trial record. Here there is no trial record, and because the court didn't ask, no record was created. When the court doesn't ask, none of ICWA's protections are engaged.
And you're saying the court didn't ask because there's no entry on the docket reflecting that the court asked, right? And isn't that the precise argument that a panel of this court rejected in the father's appeal?
Yes, but mother is distinguishable from father in the sense that she's the one who's raising Native heritage, that DCF had the opportunity to rebut that argument, the argument that there was no inquiry, and never has. Not in the father's full appeal, not in mother's petition to file a late notice of appeal, not in the opposition to the motion for reconsideration, and not in the appeal of the motion for reconsideration. Crow versus Fong says when a party has documents and information that are uniquely within their control and they do not provide it, it can be considered.
Why is it uniquely within the department's control? I don't understand that. So from what I understand, in the father's appeal, the panel said the absence of a docket entry isn't dispositive that there was no inquiry, and the parents were present at several pretrial hearings at which an inquiry could have occurred, but there's no transcript of those hearings, and therefore we can't tell whether or not an inquiry was made. That's the transcripts of the hearings are not within the department's control, right? I mean, the father could have presented those transcripts in his appeal.
Well, mother hasn't had the chance to do that. Mother hasn't had that access.
But nobody, I mean, we don't have the transcripts before us, so we can't say one way or another whether the inquiry was made, right?
Right, and it raises a question of compliance where mother hasn't had the opportunity to get the transcripts and do a full appeal. This is, trying to give her the opportunity to do that basic level of appeal in the first place.
And this issue was not raised to the trial court either, right?
Right, it's raised under ICWA.
Okay, and you're saying that's okay because it's a jurisdictional issue. And I just wanted to ask you about that because from what I understand, even if ICWA applies, the state court's not deprived of jurisdiction, right? It's not a jurisdictional issue. It's concurrent jurisdiction, unless the child's living on a reservation, which nobody is saying that the child is, so.
Well, that's why this is a case of first impression, because the Supreme Court in Holland v. Brackeen said that ICWA applies to all child custody hearings until it doesn't, until that question is asked. So it's a question that is raised before this court is, Does the state?
How is it jurisdictional? Why can't the requirements of ICWA be waived under state common law rules?
Because state law and federal law shouldn't be in conflict.
They're not in conflict. It's a procedural rule. ICWA provides certain rules, but there are overlying procedural rules provided by state common law. They're not conflicting. You can still waive the requirements unless it's jurisdictional. So, I mean, if it's not jurisdictional, I'm not understanding why it can't be waived.
Well, my sister council will argue about the jurisdiction.
Okay.
But I would make the point that under ICWA, which controls, I think in this case, that the duty is non-waivable to ask that question.
Okay.
Thanks.
Good morning, Your Honors. My name is Natalie Hoppel. I represent the father in this appeal. Your Honors, just to touch base and leave off where my sister left off, in terms of the harm I think that I can talk about that emanates from a failure to comply with ICWA is the idea that the tribe's due process rights to notice are impugned if the lower court does not only make an inquiry, but then make a determination that's recorded on the docket that provides everybody notice and finality that the lower court is properly asserting jurisdiction. In terms of jurisdiction, I can cite to the court Mississippi Band of Choctaw Indians in Holyfield. Justice Brennan, in that particular decision, indicated that the heart of ICWA is found in its jurisdictional statute, which is 1911. Goes on to say that 1911A, as Justice Shin pointed out, grants the tribes exclusive jurisdiction in certain circumstances. However, 1911B, the court states, provides for concurrent but presumptively tribal jurisdiction. So the idea under ICWA as a preemptive federal statute that applies to every single state child welfare proceeding would be that the presumption is that if you don't make the determination of ICWA, there hasn't been a proper assertion of subject matter or jurisdiction at the outset of any child welfare proceeding, such that it can be raised at any time. And we know from the regulations that the BIA promulgated, I believe in 2016, that in its 23107A, there is a second sentence that says that state courts must instruct the parties to inform the court if they subsequently receive information that provides reason to know the child is an Indian child. And I would proffer to the court that that is in fact what Mother has done in this case. When she found out that she did in fact possibly have a right within the one-year statute to appeal, she did bring forth information as she should have been instructed to do by the lower court, as we are all parties to this case obligated to inform this court that we've received information that we proffer suggests that there's reason to know that this child is an Indian child. Therefore,
What is that information? The birth certificate?
The information, I believe, is in the record appendix. It was a birth certificate and Mother's affidavit.
What is this birth certificate?
The birth certificate, my understanding is Mother's affidavit referenced the birth certificate that she obtained from family members. And it was a family member that was born, I believe, in Cherokee, Iowa. And so her understanding from her familial heritage through family members is that she has Native American heritage, and she wasn't given the opportunity to...
Does it say that it's a family member?
I believe, Your Honor, my sister in Mother's affidavit indicated that birth certificate came from family members.
Okay, go ahead. Go ahead.
Okay. Your Honor, just to continue, I'd like to just focus on the concept of understanding this court, in structural error. Structural error is something I understand emanates from criminal statutes. This is a federal statute that preempts state law. I would offer the court that if there is a circumstance when structural error in a civil situation should apply to a case, it would be when parties raise ICWA in child welfare proceedings. I can also let the court know that I did come across a structural error case in the civil arena, noting that right at present, federal law does not necessarily bar or allow structural error, but there was a Supreme Court case, and if you will bear with me, that came down recently where the court relied on, I believe, the Toomey case. So in Caperton, A.T. Massey Coal Company, which is, I'm sorry, a 2009 case, it's 556 U.S. 868. The Supreme Court didn't necessarily come out and say that structural error would apply in a tort case, but they did rely on Toomey versus Ohio, which is a more traditional structural error case in the criminal arena. So it would be for the proffer that the concept of is that if the Supreme Court relies on criminal structural error in a judicial bias case, in the civil arena, in a civil tort arena, it's well within this court's authority to consider that when interpreting federal law and applying it to a state custody case, it would not be out of bounds to look at violations of ICWA. And again, the failure to make a determination on the record that gives notice to all parties.
But we're here on a motion to reconsider a denial to file a late appeal.
Yes, Your Honor.
So it can't be that once a parent raises an ICWA issue that all state procedural rules go out the window.
I'm not necessarily saying that, Your Honor, but what I am saying is that to the extent the regulation directs or should have, the party should have been directed by the lower court to bring forth these issues. I'm not saying they dispense with everything, but they do raise a meritorious claim on appeal that would justify mother's late notice. Thank you, Your Honors.
May it please the court, my name is Carol Frizzoli and I represent the Department of Children and Families. The first thing I would like to point out is, because I think there was just a misrepresentation of the record, with respect to the affidavit of the, from Cherokee, Iowa, it's set forth in my brief at page 12. In fact, the affidavit that was attached to the petition to file the late notice of appeal was provided from father's appellate counsel. It was not at all tied to mother's, speculative Native American ancestry. In fact, the only thing in mother's affidavit about Native American ancestry was a statement saying, 2 years ago, during the pendency of the original care and protection, my aunt told me I might have Native American ancestry. Again, for 2 years during the care, that issue was never raised. So the single justice properly denied mother's motion for reconsideration of the denial of mother's petition for leave to file a late notice of appeal. If this court were to disturb the motion for reconsideration and ultimately permit mother to file a late notice of appeal, the termination for the termination of parental rights, the only party it would prejudice would be the child. I would also like to note that I do have a pending motion to dismiss in this case for fathers because adoption of Laureline, which Justice Shin properly pointed out, addressed the issue with respect to whether the ICWA inquiry was ever done. It has been disposed of. FAR has been denied with respect to father, so it's the department's position that the father has no standing in this motion, in this appeal. So again, mother has failed to show no good cause shown. Rule 14B specifically allows that single justice to enlarge the time for filing appeal, but the function is to care for cases where extraordinary reasons that the party was unable to apply for a late notice of appeal. In this case, the father and mother set forth they were represented each other as fiancé. The mother's first statement or excuse of why she didn't file the notice of appeal is she thought the father's appeal, applied to her. But again, then, 9 months go by, then mother said in her own affidavit, well, I had phone trouble, and then she said, well, I had substance, issue, and it wasn't until January 2025. Now, at that point, father's appeal had already, we had already been briefed, and we were scheduled for oral argument. At that point, mother files within 1 day of the time when her notice of appeal wouldn't even be allowed with the single justice. She files a petition to file a late notice of appeal. Only then did she file a supplemental appendix. And again, besides not having demonstrating excusable neglect, I would note that there was no affidavit provided by mother's trial counsel in the supplemental appendix that she provided. Originally with the petition, mother didn't even provide an affidavit. It was an affidavit of the appellate attorney. In the supplemental appendix, the only affidavit that was produced was mother's, although she promised the trial counsel's affidavit as well as a clinician's affidavit. Neither were ever produced, so they're not part of the record here. So all we know about mother's supposed conversations with trial counsel is what mother said. We have no verification that from her actual trial counsel during this period. In addition to not demonstrating excusable neglect, again, we have an abuse, the standard is the abuse of discretion that the single justice in not considering, again, this motion for reconsideration didn't raise anything new. It didn't point to any new law or fact that the court overlooked or misapprehended. The second issue, which mother is now alleging, is that she has a meritorious issue with respect to the ICWA inquiry. Again, that has all been resolved by adoption of law or lien by a panel. This same exact issue was resolved. There's no evidence that, or there's nothing that's been concluded that the inquiry was not done. Again, there's no one claiming. What we get to is, if you look at adoption of Breck, which is a recent published decision where this court found that in that case, the father, they did the ICWA inquiry during the course of the trial, and then father, after trial, joined the tribe and had the child. But again, it was during the child had no Indian heritage. And that's the question here. No one is asserting that they have Native American heritage or that this child is an Indian child or child having Indian heritage. So again, that's the crux here. So there's no consequences for what they're asking here. Again,
so is there any formality with ICWA? I mean, I think we'd all agree that ICWA is important.
Yep.
Correct. And sometimes I'll see a transcript of a judge inquiring of ICWA, like an emergency hearing. But I don't recall if I've seen it routinely on dockets. Is it a department requirement that it should be?
No, in fact, the statute says the inquiry must be made and recorded. But again, it could be recorded on a transcript. The fact that our juvenile courts keep a docket sheet, and now I will say it is a practice. You are usually seeing the ICWA inquiry on the docket sheet, but docket entries, I mean, many things are missed in docket entries. A lot of times. That doesn't mean the inquiry wasn't done. And in Lorleen, that was exactly this panel's question was you're assuming that it wasn't done, but didn't provide any transcripts to show whether it was done or not done.
We read Lorleen, and we're wondering why there are no transcripts in this case as well. I think Lorleen came out before the appendix was filed in this case, so we understand that. But I was just curious as to the department's practice.
Honestly, it's a procedure now that you are seeing more, that they are docketed. I know
it does seem like better practice.
It's better practice, absolutely, because then there's not a question. Otherwise, you have to go back to the transcripts and see if it was recorded. So if there are no other questions, I would rest on my brief.
I see none. Thank you.
Good morning. May it please the court, Justice Vuono and members of the panel. My name is Allison Lowe, and I represent the child in this case. And the child is asking that this court, under a standard of review that is narrow and deferential to the single justice, that this panel deny the motion, the appeal of the motion for reconsideration. Before I sort of jump into the presentation that I had planned, I do want to address three of the questions that came from the panel, and starting with Justice Smith's last question as to whether or not there is a requirement that the ICWA inquiry be made on the docket. The federal regulation, which is found at 25 CFR 23.107, and that's at Record Appendix 205. The regulation states that the inquiry is made at the commencement of the proceeding and that the responses should be made on the record. So it's not, we don't even have a mandatory language of shall be made on the record. There's a recommendation, and I would suggest good practice, that those responses are included in the record. The fact that the docket in this case does not include a reference to the ICWA inquiry does not therefore mean that the inquiry was never made. As to the question of the birth certificate, which is found at Record Appendix 281, in an affidavit of Mother's Counsel at Record Appendix 280, counsel states that she received the birth certificate from Father's appellate counsel. So this birth certificate did not originate from a family member, and it really tells us nothing. Exhibit C is a birth certificate of somebody who was born in the city of Cherokee, the county of Cherokee, and the state of Iowa. That doesn't tell us anything about who this person is in relation to the mother, whether this person has any Native American affiliation. It really tells us nothing. It's like saying in Massachusetts, there are 2 federally recognized tribes, one of which is located in the town of Mashpee on Cape Cod. It's like saying any child who is born to a family in the town of Mashpee must therefore be a Mashpee Wampanoag. Frankly, that's not how it works. And Exhibit C does not show us anything about Native American status or the mother's relationship to that person. As to the issue of jurisdiction, which Justice Shin asked about, Massachusetts juvenile courts derive their jurisdiction in care and protection cases from General Laws 119, Chapter 24, the child's presence in the Commonwealth. The ICWA statute at Section 1911, which appears at Record Appendix 86, provides that a tribe shall have exclusive jurisdiction if the child is domiciled on tribal lands or is a ward of the tribal court, neither of which apply in this case, because in the first instance, we don't have an Indian child. So certainly the juvenile court had jurisdiction to hear the case. It was not unreasonable of the single justice to deny the motion for reconsideration. And that seems to always dovetail back into, as much as I try to put it in a box of all we're looking at is the reconsideration, it does seem to dovetail back to the initial petition to late file for an appeal. And as to that, I would say that the burden was on the mother to meet the standard for filing a late appeal. Technological difficulties, misapprehension of procedural rules, abandonment of contact with trial counsel, and substance use are not unique or extraordinary circumstances. And in fact, in these types of cases, they are quite ordinary and common circumstances. So mother did not meet that element of her burden. And likewise, she failed to meet the burden of showing that ICWA is a meritorious issue. Because at no point does she allege or show membership in a federally recognized Native American tribe. And without membership, there is no ICWA. If the mother had come forward with something more, some more persuasive evidence that she was a member of a tribe, or even that an ancestor was a member of a tribe, that could be a more difficult case for the panel, but that's not this case. What the mother said was that approximately 2.5 years ago, before trial, she had this information and that she shared it with her trial counsel. She's never raised an ineffective assistance of counsel argument for the attorney's failure to raise ICWA, nor has she filed any post-trial motion to reopen the evidence. Her claims of Native American status are bare, vague, and equivocal. They are not sufficiently specific to suggest membership in an identifiable tribe. At Record Appendix 27, she says she may descend from a tribe based in Massachusetts, but doesn't tell us which of the two federally recognized tribes in Massachusetts. At Record Appendix 287, she kind of shifts gears, and she says, well, maybe I'm related to the Cherokee tribe. There is more than one Cherokee tribe, and she does not specifically identify the tribe. Then at Record Appendix 306, she shifts gears again, and she says, well, maybe it's a Midwestern tribe. So under the language of adoption of URSA, which talks about an assertion of Native American membership or connection has to be specific to an identifiable tribe, Mother has not done that here. And taken together, it is just not enough to build a meritorious ICWA claim. My client has been in state custody for almost 4 years. She has been in her pre-adoptive home for more than 2.5 years. She supports a permanency plan of adoption with her family without further delay, and we would ask that this court affirm the denial of the motion for reconsideration. Thank you.
Thank you all very much for your arguments. We appreciate it, and we'll take the case under advisement. We have one more case that we're hearing today, the last one on our list. Just Provident Healthcare Partners, LLC versus Boston Laser Eye Institute, 2025-0484.
I don't know if it's 12 o'clock or
I was gonna say, you're right,
11:59, but
we're right on the nose there, I think.
both good afternoon and good morning, I guess, then. May it please the court, Chris Marino on behalf of Boston Laser Eye Institute. Your Honors, we're requesting that the court vacate the trial court summary judgment order and the judgment and remand for further proceedings. The summary judgment order was improperly granted for 3 reasons. It was improperly granted on the voluntary payment doctrine. The 3 reasons we say is we've established the fraud exception to the voluntary payment doctrine. There was a mutual mistake of fact, which would be an exception to the voluntary payment doctrine, and Boston Laser did not make the payment itself. So the parties agree the standard of review here is de novo. It's a grant of a summary judgment, so I don't think that's an issue. Other than the fact that Boston Laser did not make the payment, which is an element of the voluntary payment doctrine, Boston Laser doesn't challenge that the payment was voluntary. I know the trial court and Provident continues to say they beat the drum that, he voluntarily made the payment. That's not an impediment when you have a fraud or a mutual mistake of fact. Both of those are exceptions to the voluntary payment doctrine that apply even if the payment would be voluntary. So the voluntariness of the payment, if there's a fraud, doesn't eliminate the exception to the voluntary payment doctrine. And there was evidence before the trial court, starting with the fraud. There was evidence of fraud. There's no dispute that this is an exception to the voluntary payment doctrine. And we don't even dispute that we would bear the burden of proof on the exception to the voluntary payment doctrine. We would bear the burden of proof of coming forward with evidence of fraud. Elements of fraud are well known to this court. False statement of fact made with knowledge of its falsity, purpose of inducing the plaintiff to act, and then reliance as to and damages. The alleged false statement here is the submission of an invoice. The trial court seemed to suggest that invoice cannot be a false statement. There are at least two cases where people went to jail for submitting false invoices that they knew were false. Now, of course, you have to prove that you knew it was false, but the notion that you can't have a false invoice is incorrect. And the invoice, under our theory, was incorrect, making it false. The question then becomes, did Provident send the invoice with knowledge of its falsity? That's the fraudulent intent or knowledge element. Generally speaking, fraudulent intent and knowledge, those are questions that are not appropriate for summary judgment.
Before getting to you're assuming that it's false, what's false about the invoice?
It seeks payment of an amount that is not due under the invoice. The contract had it.
But your client agreed that was the amount. Multiple times in his deposition, he said that's what it was worth. You're talking about the $9.2 million.
I'm talking about the $9.2 million. We're talking about that equity.
How was that false? And he agreed that that was the amount.
He didn't agree that it was the amount. That's the mutual mistake of fact. Nobody knew what that equity.
He testified in his deposition. Yes, that was the amount at the time. What do you mean he didn't agree?
Because that's what everybody told him it was worth. When he bought, the way this transaction went down, Eli Global comes to him and says, I'm going to pay you $23 million for your business. Provident is his advisor, financial advisor, and says, yep, we're going to take this deal. They then come back and say, all right, we're going to give you, $11 million.
They're more than a financial advisor. I mean, they were hired for this transaction.
Correct.
And he was represented by an attorney, correct? Not you, but another attorney.
Yes. But they're doing the transaction. If you read the equity equivalence agreement, nowhere does it say put a value on it. There's no value put on, there's no $9.2 million anywhere. The only way the parties get to that is because Eli Global is saying, I'm going to pay you $23 million. I'm going to give you $11 million cash. I'm going to give you $2 million on a promissory note. And then the balance of that $23 million I'm going to pay you is in this equity equivalence agreement that nobody seems to understand what it is because it's an unusual document. So when he says, yeah, I thought it was worth $9.2 million at the time of the transaction, that's part of the fraud. He didn't understand. That's his reasonable reliance on what
Not understanding, is that a defense?
It's a mutual mistake of fact.
Was it due diligence? I mean, what did he do or not do to understand the valuation of the EEA?
He talked to his lawyers. He had his Provident, his counsel everybody's telling him this thing's worth $23 million. And here's what you're going to get. So he looked at it, and you can't look at this agreement and understand that it's not worth $9.2 million. He later goes out and then hires somebody and says, hey, what is this thing worth at the time? And he finds out, oh, at the time it would be worth no more than $2.9 million. That's the mutual mistake.
How is that a fact as opposed to an opinion?
I think the value of something at the time is a fact.
Let's say at the time of the closing, both parties went and got valuations done. They both came back at $9.2 million. Then after the fact, he gets a different one that says, no, it's $2.9 million. So now there's a mutual mistake of fact?
I think you have a dispute of fact at that point that somebody could resolve, but it would be a different case. Obviously, it's not the case here.
It's hard for me to see how a different valuation creates a mutual mistake of fact.
We're focusing on the EEA, but the different value, because nobody stopped and thought about what the EEA was worth. It's the same thing with the promissory note. We're using the EEA, but it's the same issue with the promissory note. Everybody said you got to discount it back to present value, but they didn't do that. That's a mistake of fact. What I have to pay you is a fact. There may be some people that can disagree on it, but fair market value is the price that a willing buyer and willing seller agree to. And so what is it worth is a fact. It's a fact in courts all the time. So I think that is a fact.
Well, if everybody agrees, as you've pointed out, that that was what the value was at the time, then where can you pinpoint or say there's been evidence of that the invoice was false, that there was something false, and that Providence knew it was false?
So I disagree with the characterization that there was an agreement at the time that it was worth $9.2 million. Dr. Melke certainly testifies that he understood that was the value at the time. He doesn't agree that it was a value. He had no basis on which to agree. The line of questioning that leads to that, if you read the questioning, it starts at 2 pages earlier. He actually is saying, I've never even seen the document you're showing me. I've never seen it before. I don't know what it is. And then counsel goes through a series of questions, the last of which, well, would these numbers surprise you? No, that's what I understood it to be at the time. That's not an agreement that it's worth. It's what his advisor, Provident, the very company that's doing this, is telling him it's worth.
Counsel, Record Appendix 131 on page 80, Question, and what about the equity equivalent agreement, 9.2 million? Answer, that was the value at that point in time.
131. Let me just bear with you, Your Honor. Yes, sir, Your Honor, I agree. That's the testimony I was just referencing. But the line of questioning actually begins on the bottom of page 78 on Part 1, 131, where he says, okay, now I know your testimony is you don't remember whether you've even seen this document. But are these figures, or all these figures we just went over, are you familiar with them at the time of the closing? I mean, generally, but I don't remember the specifics. Question. There's a number here that...
We've read the transcript, but he gets to the point where he makes a statement I just read to you. He states that's the value. The fact you couldn't remember or didn't remember looking at things and maybe his memory was jogged, but he made that statement, and you now seem to be disavowing he even made that statement.
I'm not. I think you have to look at it in the context. The very prior question, starting on page 79, line 14. So I'm just asking for your understanding if you've seen this total enterprise value being $23 million. I'm just asking if you've seen that. Is that consistent with your understanding at the time of the total enterprise value was $23 million? The $23 million figure, I do remember. Okay. What does that represent in terms of value? In terms? No. But yes, I remember that was the number we were talking about at that time. The very next question is the one you're talking about. The context of that whole line of questioning, Your Honor, I submit goes to whether or not his understanding of what people were telling him at the time, the way the transaction was structured as a $23 million value, and this piece being the part that made up the gap between the identifiable components and the $23 million. So I disagree that testimony, and I think it would be up for a jury to decide whether they credit it, it's an agreement and he was acknowledging it, or whether this is his understanding of what people were telling him. We're in a situation here where Provident either believed this equity equivalence was $9.2 million, in which it goes to a mistake of fact, or they didn't believe it was worth $9.2 million, which goes to the fraud.
These are sophisticated parties, right? And Boston Laser had an attorney. They knew what Provident was charging for. If they thought $9.2 million was the wrong valuation or shouldn't have been included in the upfront fee because it wasn't paid then, these are things that could have been raised then, right? But it's hard for me to see when the invoice is clear about what's being charged, why there's any fraud or mistake of fact.
So that's a good question, Your Honor. I've litigated a number of cases where people have sophisticated counsel, and they're different counsel. Counsel don't always revisit the terms of the deal. A lot of counsel, especially in deals like this, they view their jobs to make sure the agreement memorializes the terms. And the agreement memorializes the terms. What the value is, there are a lot of lawyers out there who are not going to opine and say, no, you're not really getting a $23 million value.
You could go get a valuation. Or, I mean, why does that entitle then the party to come in years after the fact and say, I get to get reimbursed?
It wasn't. It was a short time later. And what had happened is he realized that this mistake. But the fraud here, Your Honor, and this is the point. We have a false statement of an invoice that's sent to them after negotiations between the parties where they expressly struck this provision. It's like having a contract that I say, if you paint my house, I'll pay you $1,000. I want you to paint the trim in the door. And the other side crosses out. I'm not painting the trim in the door. We're going to delete that. And then the house gets painted and I turn around and say to him, well, I'm not going to pay you because you didn't paint the trim in the door. Everybody knew at that time when they crossed this out, we weren't paying you for it.
What? I thought it had to do with escrow.
It did have to do with escrow. Okay. It did. They crossed out the language. It was what we're talking about here is a provision that said any amounts to be paid contingent upon future events shall be paid only if, as, and when received by Boston Laser. And then it went on to say, except that any amounts held in escrow shall be deemed paid at closing. And they crossed that out. And then we have an internal email where they say, despite the fact that we just closed that out, even if we have an escrow agreement, we could still argue that's paid on future contingent amounts. That's directly contrary to the change they just made. It is directly contrary. When you make that change, in my example of the house, when I strike from that provision the language, I'm not painting, or you strike from my contract, I'm not painting your trim and your doors, and then I turn around and say, I'm not going to pay you because you didn't paint the trim and the doors, that's fraud. That's Everybody understands when you strike that language, when you strike the language, except any amounts held in escrow shall be deemed paid at closing, you're saying amounts in escrow are not future contingent events. That's why in the first instance, Provident's form document says, all right, if it's an amount held in escrow, that's probably a future contingent event. We want to specifically carve that out. No, we're not going to give you that exception. And now they're going back and doing it. Now you're going to say to me, as Provident does, well, wait a minute, that's not really what we're talking about. We're not talking about an amount in escrow, so why does that even matter? Because we're talking about, in this instance, about fraudulent intent. The very reason why fraudulent intent is oftentimes not appropriate for summary judgment is because you don't get people's intent in writing. You get to, it's circumstantial evidence, but we have evidence that Provident, despite the fact that they were making this change, was not going to honor it. So what happened? It came up in a different context. Provident did exactly what it said it was going to do, it just did it in a different context. They didn't have to mess with the future contingent event on an escrow because there was no escrow. At that time, nobody knew what an equity equivalence agreement is. But when the equity equivalence agreement comes up, they're like, well, we're going to charge them up front, even though that's a future contingent event. It's, in my example of the house, it's not painting and trim. I'm saying, well, fine, I'm not going to pay you because you didn't paint my detached garage over there. It's close enough. It's evidence of fraud from which a jury should be given the opportunity to see if they agree it's fraud. They may not. I'm not sitting here and saying we're going to win. But all morning I've listened to these arguments where parties are coming in here and you guys have said, look, the juries had an opportunity to consider that. And here, the jury's not even going to give an opportunity to consider that. There is evidence from which a fact finder could find that the way Provident acted was fraud.
Could you answer Justice Vuono's question? What evidence do you have, what indication is there that the 9.2 million wasn't a valid number at the time?
We put in the record, it's the Cabello appraiser opinion of value of 2.9.
I have that, but that's 3 years later, or at least 3 years later. That's, you hired, your client retained someone to come up with that number. But at contemporaneous with a 9.2, what indication do you have?
I don't have anything contemporaneous, but to be clear, the appraisal is as of the date of the transaction. So it is as of that date, and that's done all the time in court. But as of the date of the transaction, I don't have anything other than even if it was worth $9.2 million, even if I stipulated it was $9.2 million, if you have a 3-year window where you may not exercise it, you have to discount that to present value. Any economist, if I could say the word, would tell you if you can't access, even if it's worth $9.2 million, you can't access that money for 3 years, you have to discount it. And in fact, that's what the parties did in this very instance about the promissory notes. That's why they agreed to discount it to present value. That would be one answer.
But the EEA is a different animal. I mean, the EEA was valued at 9.2 in 5 years. It could have been 20 million, right?
It could have been nothing. And that's certainly a risk they take, but that's why...
Both parties took. That's why, or it could be argued, that's why there was a value at that point. There was a value established. In 2 or 3 years in the put or the call, it could have been higher, it could have been lower, correct?
It definitely could have been higher or lower. I don't agree the parties agreed, and I don't think the record reflects that they agreed. There's that testimony. Again, I would say that's a disputed fact for the judge, but for the jury. But I thank you all for your time and your consideration. Unless there's any further questions, I'll sit down.
I see none. Thank you.
Good afternoon. May it please the court. Christine Kingston on behalf of the plaintiff, Appellee Provident Healthcare Partners, LLC. This court should affirm the application of the voluntary payment doctrine for all of the reasons stated in the trial court's thorough, well-reasoned order. This is at heart a very simple appeal. Boston Laser received services under a contract. It did not bring forth any counterclaims complaining about those services. It was invoiced, and it knew what it was being charged by Provident. It knew the basis for that charge 2 times in both the invoice and in the funds flow document sent before closing. And it admits, and under oath in this case, it voluntarily made that payment and actually did so happily. Based on these undisputed facts, the voluntary payment doctrine applies. I just want to address a couple points that Attorney Marino has raised in his brief and here today, starting off with this mistake of fact argument. And I'd submit there's no mistake of fact. What we actually have here is regret, with the benefit of hindsight. There's no dispute, based just solely on Boston Laser's deposition transcript, there's no dispute that this deal, Boston Laser was valued at $23 million for the purposes of the purchase price, that it would be paid via three components, the upfront cash payment, the promissory note, and then the EEA. And there's no dispute from Boston Laser, based on the actual factual record, that the EEA was valued at $9.2 million at the time of closing. And this is where I think Attorney Marino doesn't give his client enough credit. And if you look at the deposition transcript, it's clear. Dr. Melke, on behalf of Boston Laser, testifies that was the value at that point in time. He unequivocally testifies to that. That was the value. And he admits, I knew this was a risk. I knew this could go up. I knew this could go down. Of course, that's the nature of this business. That's the risk I'm taking. But I thought it was going to go up. And I thought it was going to go up, that value was going to go up, because this new practice group was going to acquire new doctors and new practice groups. And actually, I thought it was going to go up substantially. So that's just what happened here. It didn't. According to them, it didn't go up. It went down. And actually, according to them, it's to me outside of the record, but according to them, this is now valueless. That's the risk that Boston Laser took. That doesn't make this $9.2 million valuation at the time of closing any type of mistake of fact, nor does it make their agreement to make this payment involuntary. And I wanted to give the court just a little bit more context, because there was a question about that $9.2 million figure and where it comes from. There's a suggestion in Boston Laser's brief that this just came out of thin air, that they might have been surprised by this, that there's some mutual mistake of fact. That's just not the case at all. And I'd like to point the court to Exhibit 23 in the summary judgment record. And that's the letter of intent that's sent by Eli Global to Boston Laser in October.
Where's that in the appendix?
That is in. So that is volume 3, page 129.
Thank you.
Yeah, Exhibit 23 in the summary judgment record. So this is the letter that kicks off this deal, controls the material terms. A couple terms ended up changing slightly, but it's very clear. And this is sent by Eli Global. It's signed by Boston Laser, indicating, yes, we want to move forward with this and do our due diligence and ultimately close. It's very clear what's happening here. We're going to acquire your practice for 10 times your EBITDA, your earnings before interest, taxes, depreciation, and amortization. And you're going to be paid that purchase price, those three components we already spoke about. And on page 2 of that document, so it sets forth a specific number for the upfront payment, sets forth a specific number for the promissory note, and then it says for the EEA, the remainder of the purchase price will be paid via the EEA. So Boston Laser knows at the very start of this deal, I'm going to get, and under the letter of intent, it was 30% of the deal. They end up renegotiating to 40%. I'm going to get 40% of this purchase price via this EEA. They knew that. They knew that was the component. It ends up being $9.2 million. This was no surprise. And Exhibit C to our complaint is where Boston Laser tells Provident, by the way, Eli Global asked me to increase that to 40% instead of 30%. I agree. We're going to go forward with that. And that ends up happening. That's the $9.2 million. So this is not in any way, there's no mistake here. They knew from the start what this deal was. Dr. Melke testifies to this at length. He took a risk. He admits it was a risk, and this is pure regret. And I would also say that even assuming the record bore out some type of mistake relating to valuation of this EEA, which there's no mistake, everyone agreed to it, that's what it was at the time of closing, that's not a mistake of fact. A valuation of an equity equivalent interest is not a mistake of fact. That's classic opinion or judgment. And we know from the case law, specifically Hinckley v. Town of Barnstable, that a mistake of opinion, judgment, or law does not suffice to cancel out a voluntary payment. If there's no further questions on, there's no questions on the mistake of fact, I'd just briefly like to address this argument about Boston Laser not making the payment directly to Provident. And the trial judge says in her order, Boston Laser cited no case law for that, and I agree, but there's actually case law affirmatively holding that, not expressly addressing, but supporting the idea that a payment made on behalf of a plaintiff is legally a payment made by the plaintiff for purposes of the voluntary payment doctrine. And so just one example is the Carey v. Fitzpatrick case that we cite in our brief, which is a Supreme Judicial Court case from 1938. In that case, the plaintiff, the voluntary payment doctrine was held to apply, and the payment was actually made, the plaintiff had to take out a loan to make the payment at issue. The bank paid the defendant directly on behalf of the plaintiff, and the SJC had no issue finding that, holding that that was a payment made by the plaintiff. Just very briefly on the fraud argument, an honest mistake in an invoice or a dispute over interpretation of a contract is not a false statement. There has to be intent. There's absolutely no evidence of intent. Would also point to the fact that there's just absolutely no justifiable reliance here, even assuming that there was some false statement in this invoice.
Well, counsel would argue evidence of intent is contained in the emails.
And I think
at the summary judgment stage, one could reasonably infer that they were intending through these emails not to honor an agreement.
And I think that's where, in the trial court order, it's footnote 5 perfectly states why that's just not a rational inference. Even assuming that these emails are, and she says, admissible or relevant. So she's just assuming for the purposes of deciding, even if they were, that's not a rational inference. They don't talk about they don't talk about the equity equivalent interest. This was before the transaction engagement agreement was even signed. They talk solely about escrow. Escrow was not a component of this deal, so there's just no rational inference that you could draw that you could relate these emails to what ended up happening, and that including the value of the EEA for the purposes of the transaction fee at closing. If there's no further questions, I otherwise would rest on my brief.
One moment. No.
Thank you.
No. Thank you both very much. We'll take the case under advisement. All right, that concludes our hearing for our oral arguments for today. I want to thank everybody, all the court personnel for helping us out today. Court will stand in recess.